So the third variant is Certified Information Privacy Technologist. It's an interesting course where tech-savvy people who want to stay in data privacy but still want to align on the technology side of it, which means you're going to study a lot of technological nuances of controls, how you going to build privacy by design into your organization, how you're going to utilize different technological controls, right? So you're going to go a little deep into encryption, anonymization technique, pseudonymization technique. All right. So that's about CIPT course. And finally, we have a accreditation which is called FIP, Fellow of Information Privacy. Fellow of Information Privacy is a leadership level of recognition in the data privacy market. So if you complete CIPP along with CIPM or CIPT and showcase 3 years of relevant experience, then you can add this Fellow of Information Privacy. You need to apply, and four people have to actually agree with whatever you have been showcasing as your relevant experience, right? And how do you actually qualify to become a fellow of information privacy? So these are the different certifications which are available, and these certification definitely have a huge value when it comes to the data privacy market, right? So for this particular workshop, we are going to focus on CIPM, which is Certified Information Privacy Manager. So Infosectrain. So we provide 32 hours instructor-led training. So you can check anywhere in the globe. No one provides you 32 hours training, right? The common time frame which is generally provided is 12 hours or maximum 14 hours or 16 hours, right? So the reason is even IAPP makes this program as 2-day program. But what we are making a big difference is that these are legal concepts, and these are little difficult concept at the outset when you want to start a data privacy career, right? So you need time to digest this information. You need to go and read the official textbook along with the course content, whatever we discuss on a weekend basis, right? So you come back, brainstorm, clarify your doubts, and then further move on to the next topic. So this method has been really effective. I've been training for last 2.5 to 3 years, and there have been many successful candidates who found this paced approach of studying these courses has really helped them, right? I personally, at least, I've seen many candidates who have given a shot at this 2-day blast of going through all the content in one flow, but rather they will not be able to retain a much of information, right? This is quite natural because we may not have that same energy or same level of attention beyond a point in time, correct? So that's the reason we prefer 32 hours, and that makes a lot of difference, right? So we provide a guaranteed low price, and so I'm an approved and certified instructor with FIP. So we also provide career oriented skill based course, and there is a mock exam included as well. What is a key differentiator? The key differentiator is about the quality preparation, and we provide you sufficient time to understand the complex topic. It's a case study based approach. We'll be providing a lot of case studies to understand the topics. There are templates and other useful resources included part of the course, and there is a dedicated exam strategy session. I'll also be supporting you once the course is done. If you need a support in terms of a Q&A, you need to discuss a logic of a question, I'm always there to help you out, right? And finally, I'm also be there to provide you a career guidance in terms of if you want to switch from information security, data privacy, or you are just fresh out of college, I can really help you in terms of what are the important stepping stones, or what are the career milestone which you need to target for the next 2 3 years. We can have a discussion. I can help you around there as well. All right. So this is the reason I uh, uh, this is why you should choose infosec train. And if you feel this differentiators makes value for you, you can definitely opt us. So we are going to get started with the course. Of course, the main crux, which is the CIPM, the chapter 1, 2, and 3. Chapter 1 is the data privacy foundation or fundamentals, and then we discussed into the data governance part, data privacy governance. And the third chapter is about understanding the legal and regulatory requirements around the world. We also touched upon the cross-border data transfer, right? So we are going to discuss chapter 4, which is data assessment, right? So there are multiple data assessments which are available. We are going to discuss few of them in detail today, and it's a very interesting and important chapter, because this is going to be a very important requirement as a data privacy professional in your organization, right? So data assessments also has a important linkage with your inventory, right? And we're going to also look at different types of assessment, including your DPIA, PIA, transfer impact assessment, and legitimate impact assessment, and so on and so forth, right? Even vendor impact assessment also. Let's get started. So what is DPIA? There is a very big confusion when it comes to DPI and PI, right? So I've been hearing this question from many candidates who just start their data privacy career, right? So I like to clarify this. So you just keep this information, whichever I'm going to say, and if you get any questions in the future, you can say with confidence, this is what is the actual differences. So DPIA is a GDPR related assessment terminology. All right. So data protection impact assessment was coined after GDPR. And prior to that, we always had the terminology which is called privacy impact assessment. Now, what is the actual difference between these two assessments? Both of them are, end of the day, are a type of risk assessment. We are trying to identify a potential data privacy risk to the data subjects and trying to minimize the damage as much as possible. The intent of both assessments are absolutely the same, but how do we apply them? What are the triggers to do DPI and PIA is what makes the difference, right? So DPIA, according to GDPR, there are clearly drafted triggers, right? When you should do a DPIA. So if you are processing high volume sensitive personal data, or large scale processing of personal data, or if you are going to do monitoring human behavior on publicly accessible areas, then you definitely need to do a DPIA, right? So these triggers are indicative, and this indicative list can again be further interpreted. So there is a board called European Data Protection Board. So they release a lot of guidelines, and one particular topic is also regarding DPIA. So they have elaborated in terms of what are the possible use cases that fit into the three important triggers that is defined by GDPR, right? So this is one of the main difference between PIA and DPIA, because the trigger for doing a DPIA is clearly drafted. Whereas when you go to PIA can be applied on a multiple level. Okay, so which means tomorrow there is a Indian law which is coming, which has been enacted. Okay, so once the enforcement date is released, every organization has to do a privacy impact assessment, which is at an entity level. So understanding the impact of the law on the business is a privacy impact assessment. The same privacy impact assessment can also be conducted for a process or a product or a service as well, right? So if there is a mergers and acquisition tomorrow, there is a two company coming together, or there is a divorce when the company is splitting. So in all these cases, you can very well apply a PIA. Or for a very small activity, for instance, there is a new marketing campaign which is getting launched. Even in that case, you can launch a PIA. PIA can vary from legislation to legislation. We need to be aware about what is the local law that speaks about the impact assessment. So, for instance, Australia, Singapore, India, they use the term DPIA or PIA varyingly, right? So you need to look at the triggers for PIA, right? So when I used DPIA, it was specifically for a European terminology, but now many legislation also started using DPIA, right? So you don't need to confuse yourself with PIA, DPIA, rather look at the intent. Both of them are risk assessment, and PIA can be used at varying scale, varying intent, and for varying triggers. So you have to look at which law is demanding it. Basis that you will define your triggers, right? And for DPIA, if you look at this diagram, it clearly says the required documentation which you need to do. for DPIA. This is purely from the GDPR perspective, right? So it starts with providing a description of the purpose of processing, right? And what is the envisaged processing operation. You're going to look into if there is any legitimate interest involved. You need to assess that as well. And finally, you need to look at the assessment of necessity and proportionality. So this is all about the initial level of assessment. And when you're done this, the next step is to identify the potential risk to the rights and freedom of data subjects. If there is any risk, identify the suitable controls. If the controls are not remediating the risk identified, then you need to go a consultation process with the supervisory authority. So this is what is the life cycle or flow of a data protection impact assessment. Similarly, for a privacy impact assessment, you can draft this life cycle, but this varies from legislation to legislation. So this is for privacy impact assessment, you have a free hand. You can define, you can add even further steps, right? You can actually make it as detailed as possible, right? So this is the difference between PIA and DPIA. Hope that makes absolutely clear with everyone. Okay, now moving on to the records of processing activity. So records of processing activity is one of the very important obligation. Jay, as per Indian GDPR, can you share Indian GDPR? There is no, first of all, Indian GDPR, Indian DPDP Act. Can you share the documenting DPO is required only for organization who fit into the significant fiduciary category. All right. So there is some further clarification required, but I can't send any email. This is what is required, and this is what the organization has to do. Basically, I can clarify what the law says. The law says if you are a significant data fiduciary, you need to appoint a DPO, and you need to also have conducted audits, and you also need to do a DPIA. All right. So moving on to records of processing activity. So why this is connected to the assessments? Because if you're going to build a records of processing activity, a very important assessment has to be conducted, which is, we can call it as a data discovery, or you can call it as an exercise where you understand your business landscape, right? So this is very close to that activity to identify the personal data flows. So you need to have a questionnaire built, customized to the business process of each business units in your organization. Understand where the personal data is getting collected, how the personal data is getting processed, what are the different applications accessing it, how, where are you storing this data, what is the retention period, to which department you're sharing it internally, or you're sharing this data outside the organization. What are the controls which is used to protect the data? Is it getting encrypted while storage? There are so many factors which needs to be identified, and that is what you're going to build in terms of a records of processing activity, right? So the first important element is your description of personal data. What what are the categories of personal data that you collect? What are the data subject categories? It could be different categories in terms of employee data, it could be a customer data, or it could be your vendors data, right? And the second is legal basis. Legal basis is, in GDPR we have 6 different legal bases, right? So among that, which is the legal basis which you are pursuing to this particular data which is collected? Example, if you are purchasing an insurance from an insurance company, the contract will be the legal basis, correct? So if you are using your uh, CCTV camera in your organization for protection of your infrastructure and asset, it will be a legitimate interest. Likewise, for each and every personal data which is getting collected, you need to map the appropriate legal basis, right? The next element is your security measures. So security measures means, what are the typical security measures implemented? Basic examples like access control, your encryption, right? And if you have retention period, you have to define, if not, you have to define a retention period for each of the personal data which is getting collected and processed. How do you do it? The retention period is generally defined through your legal, regulatory, and contractual requirement along with the purpose of processing. So for instance, if my if I give my personal data to a company as an employee, my data will be retained till my employment. After that, it might be retained for another plus 5 years, 7 years, or 10 years, because there could be a law demanding to maintain ex employees data, right? So retention period for such data is 10 years, right? So this is how you will identify the retention period for each of the personal data that was collected. The first important trigger is your purpose basis which you will define, and then you also need to consider the different legal, regulatory, and contractual obligations as well. All right. The next important element which you document part of your ROPA is your recipients, which is the disclosures that happen, right? So the data transfer can happen internally as well as externally. When I say internally, could be within your company, or also within your extended organization, which could be your processes, right? There is a possibility that data can also be transferred outside the country as well. So that is where your international data transfer requirements will kick in, right? So these are the basic elements that you need to document part of your records of processing activity. So it's a very important document. If there is an inquiry from a data protection officer, this is a very, very important document which they will ask. The first document they will ask is your policies and procedure. Second document they will ask you is the records of processing activity. With these two set of documents, they can clearly identify at what maturity your organization is. All right. So this is like your company's postcard, report card. So this will give you a clear picture of where do you stand in terms of privacy maturity. All right. So the the other components of ROPA can also be extended, right? You can also add, is there a DPIA conducted? All right. So there are the ROPA can be kept very elaboratively as well. But the challenge is, whenever you define it, you also need to look at how frequently you are going to update, the effort required to maintain the ROPA up to date. So these elements has to be considered whenever you are defining the different categories that needs to be document part of the ROPA, right? So it looks very lucrative to add as many fields as possible, but if it's a large complex organization, so you may need to reconsider that aspect as well. Particular data that can be kept for eternity, right? Eternity is a very difficult justification to prove, right? Even if you can say 10, 20 years, right? Beyond 20 years, you need to prove it. See, how does data protection authorities work is that they give you free hand to define what is a retention period. So they don't come and question you. For example, they don't ask you to retain these data to these limits, but rather they allow you to define with the logic. You need to prove that logic if it is getting questioned. If you say I'm going to retain a document for eternity, you need to prove it why you need it for eternity. As I told you, they will question the factor of data minimization, Christina. So data minimization is, you have to look at the necessity and proportionality aspect of it. Is it really necessary to hold the data for eternity? Is it really proportional to what purpose it was collected? If you are able to prove it, then well and good. Otherwise, there will be a challenge. You might be failing on the factor of data minimization. Okay. So the part of records of processing activity, another extended element which we do is a data flow diagram. So data flow diagram is a visual representation of whatever we discussed in the records of processing activity. Basically, it shows the data life cycle, and the data life cycle is basically categorized into collection, processing, data transfer, and data destruction. Here, storage comes under processing, disclosure comes under transfer, right? Even archival will be along the processing as well, right? So for any set of process, even a very very small process to a very complex process, you can create a data flow diagram. So data flow diagram is not mandate as per GDPR, but it's a very effective tool to understand the data flows within the organization. If you have a very large organization, maintaining this ROPA in a automated tool or an Excel makes it really complex. But when you have a data flow diagram, it makes it very easy to understand where the data was collected, from whom it was collected, where it is getting stored, which application access them, and where it is getting transferred or destroyed. All right. So this makes the reviewer or the people from authorities, makes them understand that this is a well matured organization, right? There is a Ministry of Human Resource, and so you also have other income tax related obligations. There are other tax authorities, right? So there are many reasons where the ex-employee data has to be retained. So there are multiple laws in a country that will get triggered when it comes to these particular elements. So this varies from country to country. If a question in terms of who manages this or who has to tell this, it has to come from the legal team. So the legal team will give an overview of what exactly the law requires, and the GRC team or information security along with the data privacy team, they have to also look at the other obligations apart from the legal, which could be a regulatory obligation or contractual obligation, or it could come from the purpose. So it's a combined effort in terms of identifying the exact retention period, right? We're going to discuss, we discussed about DPIA and PIA. We did discuss about ROPA, records of processing activity. We're going to discuss in terms of transfer impact assessment, right? So transfer impact assessment is conducted part of your international data transfer. So international data transfer kicks in whenever there is a cross-border data transfer, whenever the data is be sent out of a particular jurisdiction, right? So we did discuss in the last session in terms of GDPR, there are three different instruments to do a international data transfer, right? So part of that, what is called as standard contractual clauses. So there is a big history behind this. If you are heard about this particular case called Screms judgment, so Screms judgment had a big impact on this particular topic which we are discussing, part of the transfer impact assessment, right? So the Europe and the US had a agreement for data processing, and whenever the data has been transferred from the European Union to the US, they can use that particular agreement. But that particular agreement got invalidated, the first of it, which is called as safe harbor, and the second is called privacy shield. Both of them were invalidated because of a particular case that was launched by a person called Max Krems. Okay, and so part of the second judgment, there is a Supreme Court, like an equivalent in European Union, which is called Court of Justice of European Union, and they came up with specific requirement whenever you're going to do a international data transfer, especially using a standard contractual clauses. So transfer impact assessment is not a GDPR terminology, but rather a industry coin terminology, which means if you're going to use standard contractual clauses, you need to do a transfer impact assessment, which is invariably embedded part of it, which means you have to look at 6 important steps. The first step is know where you are transferring your data. You need to identify the which processor, sub processor who is going to receive this data, which country they belong to. The reason for that is you need to have a good understanding, especially what are the laws that prevail in that country, what are the practices that prevail in that country. All these elements has to be identified. That's the reason you need to clearly understand to whom you are transferring your data. Second is identify the transfer tool. So we discuss about the different transfer tools which are available for international data transfer, especially under GDPR. We have adequacy decision. The second is security safeguards. Under security safeguards, under safeguards, we have SEC, and we have ad hoc contracts, we have certification, we have binding corporate rules, and these are some of the different transfer tools which are available to do a international data transfer, right? The third is assess the third country, whichever is receiving the data, their effectiveness, or in terms of how do they respect the data privacy in general, right? So that's the reason, even if you look at the adequacy decision parameters which the European Union Commission assess is that how the country has enacted specific data privacy laws, how the data subjects in that country can raise concerns, which is through their data subject rights. So there's a lot of these factors will be assessed before awarding a adequacy decision, correct? So similarly, we are going to look, this is from an independent perspective, part of the transfer impact assessment, looking at how the third country respect data privacy, how do they handle data privacy complaints, and all these things has to be assessed, part of step 3. Step 4 is identify, adopt the supplementary measures. For example, you have identified certain risk. There are certain countries which give some sort of unprecedented or too much powers to the law enforcement agencies, right? So which means they can open a data center, they can go and open a server and fetch the information, even though the cloud contract says that information is absolutely secure, but the local law enforcement agencies may have such powers to tap the data out, right? So this is the reason you need to identify the risk, part of the step 3. And if you have such risk identified, not the one which I told you, but there could be other risk which could have been identified, part of the step 3, right? So for that, you need to identify the additional supplementary measures, and then you need to transfer using those supplementary measures which are available, and finally de-evaluate the entire 5 steps on a periodic basis, right? So this is the transfer impact assessment, which is generally used for cross-border data transfer. The references whichever I'm giving you are predominantly from GDPR, because GDPR has a detailed notion when it comes to international data transfer, right? So if you ask the same question from the Indian DPDP Act perspective, we do not have any limitation to do an international data transfer until the central government releases a set of countries which are basically blacklisted. So except those countries, you are free to do an international data transfer, right? So again, this will vary from regulation to regulation, legislation to legislation. All right, this you need to be mindful of. So vendor risk assessment. Vendor risk assessment is one of the very important due diligence which the organization has to take up. The reason is, uh, you are going to engage with processors, and the processor may engage with a sub processor, right? So in this case, the personal data whichever is collected from the customer is trusting the controller for it, right? The trust factor is always between the customer and the controller, but the controller is engaging a processor, and the processor is in turn engaging a sub processor. So this becomes a ecosystem, extended ecosystem, where the personal data is getting transferred from one entity to another entity. The controller may have a very rigid data privacy practices or information security control, but is as good as equivalent to the data processor and sub-processor category controls, whatever they have, right? Which means if your processor and sub-processor are not maintaining the same rigor of controls, then obviously you are not gonna uphold the trust whatever the customer has kept on you, right? So this is the reason the accountability factor kicks in here. So whenever you are selecting a processor, you need to do a lot of vendor due diligence, right? Vendor due diligence includes identifying the right processor who provide you sufficient guarantees. The guarantee can come in different forms. For example, they have a robust information security program, they have certifications, they have credentials. Credential means they have a word of mouth, or someone from the industry, their past customers are vouching for their strong information security practices, right? So there are multiple parameters that needs to be assessed. A classical example is your cloud vendors, right? So whenever you are planning to move your organization data to a cloud model, you generally go with the giants, which are Google's, your Amazons, and your IBMs and Microsoft, right? So if you choose someone beyond this category, then you need to do a lot of due diligence in terms of how secure this information has to be kept, and how the data sovereignty will be maintained, or the security controls, how the data is going to be returned back. There is a lot of factors that you need to consider, right? So again, a cloud service provider will be a processor, right? So that is the reason this vendor risk management is a very, very important part of your data protection and data privacy as well. Because if there is a failure from the processor, if there is a breach at a processor end of the day, the accountability is again going to be with the controller only. Although the controller would have implemented every possible control, they have a very robust practice, but still a failure at a processor or sub-processor end, it is going to be attributed to the controller to a certain extent, right? So the controller has to prove in that case that they have done all possible due diligence, but still there was a breach at a processor and sub-processor end. So that maybe at that instance there is a limitation of liability. Otherwise, there is definitely be a question in terms of your vendor due diligence process that is being carried out. All right. So this vendor risk management framework is a sample of what are the different steps which is need to be conducted part of the vendor risk assessment. All right. Just for a reference, so let's go to a few question and answer based on this particular chapter. So answer is A. Okay. The best way to understand the organization's poster is always going through the data inventory. If you recall this point, the data protection officers, whenever there is an inquiry, they generally ask for two important documents. One is your policies and procedures. Second is your records of processing activity, because records of processing activity will give you a complete picture of how the personal data is getting collected, transacted, and processed within the organization. So analyzing the data inventory is the right answer for the first question. All right. So second question, why do we need a privacy operation lifecycle? Because if you see, there is a lot of changes that happens around us. There is a lot of changes in the law, regulatory requirements, sectoral requirement, contractual obligations. So there is a lot of things that keeps changing around us, right? For example, tomorrow consent requirements might change. There is a lot of changes that happens continuously, right? So that's the reason function of privacy operation lifecycle, it helps us, it allows us to respond to the ever changing privacy demands, right? Because once you have a structured approach, it helps you to consistently apply those policies and procedure whichever you have created, and helps you to achieve your overall objective or your privacy vision and mission. So answer is B. Okay. Question number 3. Interesting question. Data inventory is your records of processing activity. Okay. So if you remember the different categories which we discussed during records of processing activity, which particular activity will trigger an update? But the question is negative sense, right? All of the following will update data inventory except. Okay. So these are the questions you might get in the exam, which is like negative or double positive, double negative. So you need to be really careful when reading the question till the last word. All right. So if you see the options, which is If you're outsourcing your CRM function, there is a new vendor coming in, which obviously is gonna trigger your inventory. Acquisition of new subsidiary definitely will trigger inventory. Onboarding a new vendor will also trigger an inventory update. Whereas a passage of new privacy regulation doesn't trigger an inventory, but rather it will create new rules and regulations or requirements for the organization to follow, right? So passage of new privacy regulation will not exactly trigger a data inventory update. All right. So question number 4. So if you remember the DPIA statements, okay, it's a difficult question for you to exactly remember, but if you read this question, I will help you to understand. So whenever there is a large scale sensitive personal data processing or large scale personal data processing, and if there is a monitoring activity which happens, monitoring happens through CCTV or it happens through your profiling, right? So these are some of the examples for which we do DPIA, right? So if you look at the different options which are there, what exactly causes a sort of a high risk to the data subject, right? So out of these options, okay, if you look at option B, looks very tempting because people immediately look at a healthcare data. You think that has a very significant risk. But if you look at the actual option, healthcare professional process personal data from patient file, it's a very routine activity that happens on a day-to-day basis, and it's a legitimate use as well, because you are going to use the patient information to treat that patient, to refer the past history. So that doesn't actually trigger a DPIA. If you look at option A, credit scoring platform 5 years ago. So it's a very incomplete statement. There was a credit scoring platform that was created 5 years ago. Am I worried about the risk of that particular platform? Not essentially, because when it was created 5 years ago, there could have been some assessment could have been done, right? If not done, I still look at what is the element of personal data attached to it. What is the impact on the data subject? To me, option A is definitely not that significant. If I go to option C and option D, if I look at option D, if a school process children's data for transportation, scheduling any customization, which means routinely they maintain a rooster for the drivers, right, for scheduling purposes. This looks a very routine activity, and I don't see a significant risk in this case to the data subject, because yes, the personal data is getting collected, but it doesn't alarm me in terms of a possible risk. Whereas if you look at option C, a social media company created a new product compiling personal data to generate user profiles. This is a very significant activity that touches the point number 3, which is monitoring of human behavior, right? So monitoring of human behavior, here it happens to direct profiling activity. Profiling means generally you are trying to combine what is available with you, or you're trying to scrape the data which is online and trying to create a profile about a particular user. When you create a profile, you intend to use that information for direct marketing activities, right? So that is the reason this will pose a significant threat to the data subject. So this is how you need to dissect your answers. You need to understand exact problem statement, which is here the DPIA, and read every option to know which exactly triggers the statement that is defined. So this is a CIPPE question, but this is also a possible question for CIPM as well. So this is how you need to go through the options and arrive at. This is a slightly difficult question, but these sort of questions you can definitely expect in the exam. All right. Option answer is C. So let's go to chapter 5. So chapter 5 is about how do you protect your personal information. So the assess part is done. If you remember the operational life cycle, we started with the assess phase, right? So assessing is done. Now you know what are the risks through your PIAs, DPIAs, transfer impact assessment, or your vendor impact assessment, legitimate impact assessment. So with all these different assessments, now you know what is the potential risk. So at this stage, you need to protect the personal information, which is your protect phase of your operational life cycle. part of this stage, you're gonna embed privacy by design and identify the suitable controls to protect the personal data against the risk which you have identified, right? So this is chapter 5. In chapter 5, I'm gonna start with privacy by design. So privacy by design and default uh, is a research topic when it was started, or it is a philosophy that was what was introduced by Anna Chuakin. So she was the Ontario from Canada Privacy Commissioner. So she came up with the 7 principles, which is called privacy by design. So the privacy by design principle was officially adopted in GDPR, and it's a mandate for the organization to embed privacy by design requirements. Do you need the extent to know all these principles in detail? Answer is no from the CIPM perspective, but at least you need to know what is what. Okay, so the first principle is which is privacy as a default setting, right? So sorry, first principle is proactive not reactive. So proactive not reactive, preventive not remedial, which means you need to be proactive when it comes to privacy controls. Privacy should not be an afterthought. Generally, when do you do a DPIA? DPIA has to be done at the earliest as possible whenever the product process is at an inception stage, right? So that is the example of being a proactive. And you shouldn't retrofit the privacy aspects into a project or into an organization. So that is the example of being a reactive, right? So the second principle is privacy embedded into design. So for example, whenever you are building a website, so how do you build a website in terms of your cookies banner? So cookie banner, you need to embed your privacy, like the how do you collect your consent? Are you using a pre-tick box? Are you giving explanation of what are the different cookies that is getting collected? All these things are example of privacy embedded into design. So the design can be for a product, for a process, or a tool. You can extensively give examples for privacy embedded into design. The third is respect for user privacy and keep it user centric. So this has to be a trust related aspect. You should always respect the privacy of the users. This is more moving away from compliance, where rather keeping trust as the key differentiator for your organization, right? If you believe trust of a customer can be or winning differentiator, then obviously they are going to follow this principle, right? So there can also be many examples to that. I'm focusing right now to cover just the 7 principle. Visibility and transparency. Visibility and transparency is very closely related one of the principle of how transparent you are with the data subjects, right? How do you be transparent? Whenever we are collecting personal data, you need to give adequate information about that particular processing, right? You need to collect the consent only after providing a proper notice with regard to how the personal data is getting collected, what is the purpose of collection, how you're gonna retain it, how long you're gonna how you're gonna if there is a transfer involved, and who are the recipients of the data. All these elements has to be absolutely transparent, and you need to provide that visibility to the data subject before personal data is getting collected. Full functionality, positive sum, not zero sum. Very interesting with the outset, because this keyword is generally confused, which means uh, you need to create a win-win situation. For the sake of privacy, you should not compromise your business process. For example, if you become too, I'm unable to hear the voice. Is it? I'm not sure, Khalid. Check at your end. Maybe it's a bandwidth issue at your end. So positive sum not zero sum is a classical example of you need to create a win-win scenario synergy and ensure that you don't compromise for any aspect. Privacy should not be compromised for business purposes, or for that sake you should not make privacy a very restrictive towards the business growth as well, right? So it should be a win-win combination. That is what we call it as positive sum not zero sum. End-to-end security of which is full life cycle protection, which means you need to have your data protection controls part of every stages in the operational life cycle, right from collection to your dissemination and destroy stage of it. And the next one is privacy as a default setting. So this is again an interesting principle, which means whenever you're using whenever you're creating a process or a product or a service, you need to embed privacy before a customer asks for it, or a regulator is requiring it part of a law or a regulation, right? So this is an example as privacy as a default setting, right? So for instance, I proactively, whenever I collect the data, I only ask the minimum information which is required to process that particular process. Example is your KYC information. When I collect a KYC information in a form, I only collect the bare minimum personal data that is required exactly for that particular process. I do not collect any excess data. I don't want to remove a particular question. After someone question me why this data is collected, or how this data is related to the processing which happens, right? So this is an example as privacy as a default setting, right? Generally people confuse privacy by default versus privacy by design as two different terminology, but rather privacy by default is one of the principles within privacy by design. All right, so this is another important clarification which I thought to give you, part of your data privacy by design. So I'm not going to go into depth of this. So this is an example of your privacy by design strategy. So there is different strategies which is generally there, which is called data oriented strategies, process oriented strategies, and finally we have something which is technology oriented strategy, which is called PETs, which is privacy enhancing technologies, right? So these are mainly information for you to have a overview. So we will not be going into depth of these elements. We will be covering these things in detail during our sessions, but just trying to give you an idea what are the different types of privacy by design strategies are there, right? There could be data oriented or process oriented or technology oriented. All right. So what are the different controls which you can apply for an organization, right? So after assessing your privacy risk, part of the assess phase, now you can apply different types of controls. So these are controls which is coming from the information security perspective, and there are specific data protection controls as well. But just to give you an overview, this is again tested from the IAPP exam perspective. Physical controls, technical controls, and administrative control mapped against the objective, which is preventive, detective, and corrective. So what is preventive? Preventive controls are the ones which used to prevent a particular risk from materializing. Detective control is the one which we will identify, controls used to help you identify the risk at an early stage. So once you have identified the risk, corrective control helps you to minimize or mitigate the possible or potential risk, right? So this is the objective. These are the types, which is physical controls, which is basically your controls at the entrance of your company, or related to the physical aspects of the process. Technical controls, which is your firewalls, IPS, multi-factor authentication, antivirus, which are basically in technological nature. Administrative controls, which are your process and procedures. So this is an excellent map that gives you versus the types of control versus the objective based, which is your preventive, detective, corrective. There is one more classification which is called deterrent controls. Deterrent controls are basically trying to discourage a particular threat or a threat actor from attempting the particular risk, or causing the risk, right? That is a deterrent control. So this again is a topic which is often tested in the CIPM. So I hope this is clear. We'll jump on to few exam questions, so that helps you to know what sort of questions are tested here. Question number 1. So the question is again a negative question. Does legislations or laws list the technical controls? Answer is no. Basically, no law will go to the extent of prescribing what exactly the controls that has to be implemented, right? If you can go to GDPR or the Indian Act, DPDP Act, anywhere in the world, the law doesn't go to the extent of prescribing exactly what are the different technical controls. For instance, in GDPR, you only find two references or some good practice which is mentioned. One is pseudonymization and second is encryption. So these are the only controls which have been suggested as some best practices, right? So they don't go beyond exactly in terms of what sort of encryption, what sort of pseudonymization we have to do. There is so much of detail into it, but the law says you can try these controls as a minimum base standard or a good practices, right? So the answer is C. Next question. It's a tough question in terms of not understanding GDPR, but I will try to make you understand this question. I picked this question to make you know the obligations of a controller and processor, okay, from a control perspective. So in GDPR, processor also has important role and obligations, right? So one important obligation which is given in GDPR towards a processor is that they need to implement technical and organizational measures. Okay, so controller and processor have different set of obligations in GDPR, but there are some common elements when it comes to these obligations. One such common element between controller and processor obligation is both of them have to maintain technical and organizational measures. Both of them have to maintain records of processing activity, right? So there are 3 to 4 set of activity which is common to both controller and processor. Because even if you are a processor which is appointed by a controller, but the processor are answerable to the data protection authority if you have not implemented appropriate technical and organizational measures. Okay, so that the answer is C. So we will move on to the next chapter, which is policies and procedure. Quite easy chapter. So this is the next stage of which is within the protect. We are gonna go in terms of how do we build your policies procedures to enable the organization respond to the risk identified, right? So it's one of the quite easy chapters in terms of understanding what are the different policies and components of privacy policies, which is your different procedures that exist in the program, right? So this slide speaks about what are the different components, right? What you need to do part of your privacy policy, right? So to do or to create a privacy policy, you need to first understand the business landscape of the organization, what type of personal data you collect from different channels, right? There could be multiple channels for an organization to collect personal data. It could be from your sales, it could be from your marketing, it could be from your HR. There are so many channels through which personal data comes into an organization, right? So this is a very important factor for you to understand to create a privacy policy. And second is the purpose of processing. You need to understand why are you collecting this data, right? That will help you to identify the corresponding privacy policy obligation requirements controls there and therefore. And third is, do you regularly review the data for accuracy? Because accuracy is a one important element for your GDPR related principle. There is a particular principle on accuracy. So whatever data you collect, you need to ensure the accuracy of the data over the life cycle. The next one is, how do you store the data? The data can be stored in encrypted, unencrypted format in an application. It can be stored in cloud, on premise, off premise. So there are so many factors when it comes to the storage. Along with the storage, you need to also look at the retention period, which is point number 5. And point number 6, how can you readily comply with the individual's right to access, erasure and portability? So privacy policy, when I say privacy policy, this is just an outset of different components of your privacy policy. So along with this, you need to drill down further in terms of different procedures, which could be your breach management procedure, retention procedure, your data subject access right procedures. There are so many procedures that needs to be created along with the privacy policy that will help the employees to consistently apply the requirements of a privacy policy and procedure, right? The next one is value creation through your privacy policy. So it's a more of how a privacy policy, when it's created, how it add value to the organization. So it helps to create a standard with your governance. It helps you to implement appropriate security controls. You have a proper life cycle management. You have a better control over your contracts, notices, complaints and dispute resolutions, building appropriate policies, procedures, which is exactly to the objective, breach handling, notification process, training and awareness, and data handling procedure. If you look at the right hand side image, that is what I wanted to show you as building a privacy notices, right? Privacy notices again is one of the element which is a drill down part of your policies and procedures. Then you go in terms of creating privacy notices appropriate to your channel. So there is a concept which is called a layered privacy notice. So layered privacy notice, I think there is a slide on that, but you have to look at the different channels wherever you're operating. Basis that you need to create your privacy notice. One classical example is your mobile phones. So mobile phones has the limitation in terms of space, correct? So how do you squeeze your privacy notice into that? Because privacy notice is an important legal obligation as well. At the same time, you need to also look into the fact that there is no privacy within a mobile phone screen. So for that, you can have the option of bringing up layered notice. So layered notice is a concept of presenting the most important information in the first layer, then drilling down into subsequent layers based on the interest and the availability of the data subject, right? So this is one concept we will be discussing, part of how do we create privacy notices. And the second aspect is your employees personal data lifecycle management. So employee life, so when we say privacy policies and procedure, it's not only targeted to the customer, and we also need to protect the employees personal data which is getting collected and processed in the organization. So the employees personal data is has touch points in various aspects. For example, right from a candidate applying for that organization, the CVs are collected, contact informations are collected. So then there is an interview, there is a recruitment drive which happens. There's so many personal information which is getting collected, and then the workplace, when the finally the employee is created and a very big employee profile is created, so many personal and sensitive information is scheduled there. Your medical leaves, your family details, there's so many information which is kept part of your workplace, your payroll information, and your aptitude, your performance, and when you finally leave, your other elements which includes your official letters, right? Experience letters and other things, right? So all these elements has a very high touch points of personal data, right? So that is the reason maintaining an employee personal data itself is a very big task. We need to pay enough respect in terms of how do we have controls. One common controls is who has access to the data, what extent. Generally it is restricted to the HR, and only few project managers will have access from time to time. For example, your appraisal management should be locked only to the concerned uh, manager, right? It should not be available to every manager in the organization. That's something, a common flaw which we have seen. Someone like a manager and above cadre will have access to everyone's appraisal. That is not a right approach, because the opinions which you draft part of your appraisal management is a personal data about that person, right? So these are some of the nuances which you need to understand when it comes to employees personal data management, right? So apart from that, you also have something called whistleblowing schemes, right? Again, these are again very sensitive areas. Whistleblowing schemes have a lot of personal data and sensitive personal data touch points, and also work from home policies, incident response and breach management procedures. Work from home policy also is a very sensitive area, because not only the company's data is getting handled. If you're working from home, a lot of information from your device might also get traced and tracked. If you are bringing your own device, again, that is again another critical area. For all these elements, you need to have a clearly drafted privacy policy and supporting procedures, right? So this is all about this particular chapter. We will be discussing all these elements in detail when you come for my session. All right, many of you got it right. Whole disk encryption is the right answer. So if you go to any corporate, generally they have end-to-end encryption for the laptops. So answer is D. Okay, that was an easy question. I think I have only one question for that, and I'm gonna move to chapter 7, which is your monitoring and auditing your program performance. The reason is last chapter, tomorrow we'll be discussing the exam strategy. We'll also be discussing some of the interview questions, right? So I thought to cover till chapter 7 till today, and then we will discuss the chapter 8, 9 and 10 uh, tomorrow, right? So this is again an interesting chapter, which is the next phase of your operation life cycle, which is to respond. To respond in an operation life cycle, you need to do a continuous monitoring. Sorry, the third stage is sustain or monitoring stage, right? The final stage is respond. Before responding, you need to monitor your privacy program, right? So to monitor, you can do audits. Even before doing an audits, you need to define your KPIs and metrics, right? So these are some of the important elements which is required to assess your effectiveness of your privacy program. Are they achieving the intended objectives over a period of time? What are the different types of metrics which are there for each of the different components of a privacy program is what we will discuss part of this particular chapter, right? So data privacy audits. Data privacy audits is becoming a norm of this particular uh, uh, 2 3 years, or last 3 4 years. There is a big emphasis on data privacy audits. Generally, when we say audits, we tend to remember the ISO audits or information security audits. But if you go to the European Union region, this data privacy audits is getting a lot of traction. The same will happen in the Indian DPDP Act as well, because the Indian DPDP Act explicitly demands a data privacy audits if you are a significant data fiduciary, right? So what are the different types of data privacy audits which we do is your data processor review. The due diligence, whatever we discuss part of the vendor assessment, will be audited maybe by a third party or an external auditor. The data lifecycle management, which is generally a review of your records of processing activity in terms of have you identified the right lawful basis to in terms of retention period, in terms of exactly mapping the data flow, cross-border data transfer instrument. So all these things can be assessed part of your data lifecycle management audits. And the third is control maturity assessment. So this is a very commonly used privacy audit type, which is assessing a organization's privacy maturity. So you would have commonly heard the CMMI cycle, right? So similarly for data privacy also, we have a privacy maturity model. So privacy maturity model has very similar 5 stages compared to CMMI, with a slight change in the stage of phase 2. All right. So again, this is a very important audit which assess a privacy maturity, and this is a very common question in the exam as well. They will give you a scenario to understand which exact stage this organization lies. We will see in the upcoming slide. there are types of audits which generally happens, which is your first party audit, second party audit, third party audit. So first party audits are generally, we call it as your organizational audits. For example, your internal audits which are being done conducted by the organization, right? These are all called your internal audits. Your information security team, risk management team, all these departments will conduct your routine audits, which is your internal audits, right? So that is called your first party audit. Second party audits are called supplier audits, which means there is a controller, there is a processor. So the processor is also periodically audited by the controller themselves, right? So they have this clause added part of the contract. So part of that, they do a periodic check on the processor. This is called as second party audit. The third party audit means you engage an uh, 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 independent auditor from a reputed firm to do a third party audit. So their independence is the most important key aspect when it comes to the third party audit. So these are the types of audits which you need to be aware of. Metric analysis. For example, first, before you even go to the analysis, we need to define the metrics for the different components of a data privacy program, right? Very, very important aspect, right? From training and awareness, data breach management, your compliance to the legal and regulatory requirements. These needs to be documented and captured for the top management decision making and direction. So dashboarding when it comes to data privacy management is equally important, like we do for information security, right? So dashboarding helps you to show where exactly the organization stand in terms of the privacy program management maturity, right? So to do that, you need to define metrics itself is a separate art in terms of identifying the right metrics, collecting the right values and monitoring it over a period of time. So this helps the top management get a clear view, factual statement to decide on the future of your privacy program management, right? From return on investment, there's a lot of factors that can be measured. So to do a metric analysis, we have four different methods. The first is trend analysis. We will discuss that shortly. The second is return on investment. When I say return on investment, the amount or the cost, whatever you are utilizing versus the benefit, right? So this is what you generally do a return on investment. This is a main ask for the CFOs, Chief Finance Officer, right? The reason is information security, data privacy is all considered as cost centers, right? So they don't see revenue generated part of these particular streams. That's the reason they always question in terms of any investment that goes to these particular disciplines of the organization, right? So that is why you need to prove your return on investment to the top management. How can we do it? You need to calculate the benefits over the cost. How do we show the benefit of a data privacy program? It can be showed in many ways. For example, the litigation cost, the cost of a data breach, the remedial cost. There's so many factors that can be showed in terms of benefit. For instance, a single breach can cascade into multiple separate breaches. For example, there is a data subject breach of a sensitive personal data, right? This can cascade into individual litigation cases. There could be a penalty slapped by the supervisory authority, right? There could be a penalty come from your third party engaged with you as well as a contractual obligation. So there could be a huge reputational loss, future business loss. So there are so many factors which you can cater, which you can bring into this calculation to make the top management understand that we are trying to avoid all these costs by having a robust privacy program, right? So this is how you need to convince your top management when it comes to data privacy investments. Moving on to the business resiliencies, right? So we will discuss business resiliency. Screen is not visible. Anu, I have not changed anything, so you need to check at your end whether there is an issue. So business resiliency is typically in terms of how efficient your organization recovers and come back to normal stage. So that is business resiliency. Uh, uh, your trend analysis is something which is very important, which is time series, cyclical component or irregular component. Anything plotted to understand a trend, positive trend, negative trend, all this is generally done with the metrics data. For example, time series, if you are seeing an increasing trend of people performing their roles and responsibility appropriately, or there is a decreasing trend on the number of breaches, right? So this is plotted in a time series. What is cyclical? Cyclical means there is a criteria, right? The weekly, monthly, or a yearly pattern. After implementing your data privacy program, what is your efficiency of your data subject rights over a period of time? How many data subject requests are you fulfilled over a period of time? A criteria with a particular cyclicity is cyclical component. Third is noise, which is irregular component. For example, there could be an outlier, right? So this again can be plotted to show a irregular component. This is the privacy maturity model which I was trying to tell you before, which is one of the privacy metric analysis method. So there are 5 different phases, which is initial, repeatable, defined, managed, and optimized, which is very similar to uh, CMMI model. The only difference is here the second stage would have been managed, and this is quantitatively managed, right? So in PMM, which is privacy maturity model, screen gone. I think it is working now. I guess there was a temporary issue at my bandwidth. I think it's working now. Kindly check again. Yeah, it's
We don't
working
see
now.
the screen
Correct.
again, sir. Sorry, we
Yeah,
don't see
you're
the
able
screen.
to see. You're
No,
not
we
able to
don't
see
see
the
the
screen.
screen. Yes, we don't see the
Uh,
screen.
uh,
Now it is again coming back. Now it is again coming
it's
back.
coming back, right? Yeah, yeah. Sorry, there was a fluctuation at my end. Okay, unfortunately, it happened. So hope this is working now. Yeah. So these are the 5 stages when it comes to privacy maturity model. So I'll explain you what are the 5 stages is about. Forget about this detailed chart, just trying to make you understand at least what are the 5 stages and what does it mean. So you will get a clarity on privacy maturity model, right? The first stage is initial, which is completely at a nascent phase or completely from zero scratch. You're starting an organization. There's completely ad hoc process. There is nothing which has been streamlined, either documented, right? So this is called initial stage. Repeatable stage, which means there is a consistent approach, but mostly the process is not documented. This happens in many organizations. They say we have a process, we follow it, but we never document it, right? So this, they all fall in the second category. They can repeat the process, but they don't have any documentation to prove it. The third is defined stage, which is they have a defined documentation stage, and but they do not have a measuring in terms of KPIs. KRIs are not measured to assess uh, uh, the the process effectiveness, which is defined. Third is manage, which is effectively the process and procedures and everything are measured. You identified where you stand, right? And so this no this manage stage is one of the best level an organization can achieve. And the final stage is your optimally improving over a period of time, which means you are done all the factors right, you are documented, you are assessing your metrics, you know what are the areas you can improve over a period of time, and if you're consistently doing that, that will be the optimized stage. All right. So this is the 5 stages of PMM, which is also part of your metric analysis. All right. So we had 4 phases, right? Assess, protect, sustain, and respond. So we just started this chapter, and that's an indicator that we are at sustain, right? So sustain is about monitoring the organization, so which includes your audits and other monitoring activities, including your defining your metrics and all this stuff, right? So answer to the question is sustain, option B. Okay. Yeah. Second question. We discussed different types of metric analysis, right? We saw return on investment, trend analysis, business resiliency, and privacy program maturity, right? So this particular type of analysis will fall under which category? It's a trend analysis, right? It's quite straightforward. Question number 3. Again, a quick straightforward question. The keyword here is independently audited. So independence is usually achieved with a third party audit only. All right. Question number 4. Within trend analysis, we had 3 factors, which is your cyclical, irregular, which is noise, and the first one is over a period of time, positive or negative trend rate. We call this time series. Yeah. So answer to this question is cyclical, right? So the keyword here is next 6 months. You are looking the effectiveness of the training, right? So if you're measuring over a period of time, you are trying to assess it over a quarter or annual basis. So these are example of your cyclical trend analysis, right? So answer is cyclical. Let's go to question number, is it 5? All right. So it's an interesting question. If a organization has just been attacked, there is a breach, right? What is the metric which is not relevant in in this particular situation, right? If you look at the first option, number of security patches applied to a company device. So this makes sense because you are right, you are in a situation, your company has been breached, right? How many security patches have been applied to all the devices, the periodicity and blah blah blah. There's a lot of things you can assess part of the patches, right? So this is a parameter you can assess to know the effectiveness, and you can also try to find the root cause. So this metric makes sense. Number of, let me go to option C, number of privacy impact assessment that has been completed. It makes sense. If the number of process products and services have not been assessed periodically with privacy impact assessment, so that can also be a root cause that you have not identified the potential risk at an early stage. Option C, number of employees who have been completed on data awareness training. So this is a very important element because the periodicity of data awareness has not been provided, then that can definitely become a root cause for employees to make a human error, right? So that is also a relevant metrics to know in terms in a breach situation. Option B is number of data subject requests that has been exercised. It's a good metric. It's a legal requirement, but is it relevant to the breach situation? Answer is no, because data subject rights is a very important requirement a data protection officer needs to know. But in a breach situation, option A, C, and D makes more sense to have those information because that helps you to do an impact assessment on the breach. Correct. So option B doesn't make a great sense. That's why option B. Okay. Hope that clarifies. Let's go to the last question. Question number 6. Okay, so the answer to this question is option D. Okay, the reason for that is Summit has actually developed a very robust privacy policies and procedure, right? If there is any change, the change needs to have a clear reflection in terms of what are the relevant things that has to be done, correct? But is he measuring or monitoring the organization? Is he really looking into how the policies and procedure has been implemented or affected? So that is where the problem, root cause of this particular problem statement, correct? So failure to monitor environment is where it went wrong. Completing DPIA makes sense as a one-off case, but basically if you look at the problem statement, Summit has a robust privacy program in place, right? Which the policy clearly says that if you are making a change, then the privacy program manager has to be a part of the loop and he has to do his relevant assessments, right? But the problem area here is that how effectively things are getting monitored is not defined by Summit. The metrics have not been defined, the monitoring requirements have not been defined. That is where it went wrong. So he has not been monitoring the environment, which but they have a robust program in place. See, robust program is as effective as in the paper. It's not in the ground. That is what the meant, Mr. Amar. Okay, so that is where it went wrong. So answer is D. Hope that is clear with everyone. That's it for today's content. Okay,